sooner than later period of time, until such time if the global policy mantra comes in terms of how this particular tax should be levied, in what form, whether to bring it in tax statute as Mukesh ji said, or what should be the ways and means or the protocol of this, which is an agreed upon solution by the large economies of the world, including big market economies, which are huge consumer of such services. So till the time we have this, I think this is here to stay. Just to add one bit in terms of resolution, if I can speak now.
Recording stopped.
Good, recording has also stopped.
Recording in progress.
In terms of resolution, I think Mukesh ji, you've been pretty much one of those pioneers who looked at US mutual MAP programs. In 2003, US, we had a circular in 2003 which does suggest, or not a circular, which was an instruction number 2, which came in April 2003, that if you invoke a MAP, which is an alternate dispute redressal for the purposes of taxation, and both the tax authorities of both the countries, competent authorities, do agree to figure out ways of eliminating economic or other forms of double taxation, there will be a suspension of tax collection if the MAP proceedings are in underway. To which just a one pointer, and I can't get away with the temptation of citing judgments. In 2013, there's a very interesting judgment of Bombay High Court which said that what do you mean by admission of MAP proceeding? Does it, in the case of UPS, does it mean?
Thank you for that. Coming back, Badri, to you, we have seen a surge in the OIDR classification for GST, which is for the import of specified services. And given the fact that India continues to be a large importer of US services, particularly digital services, what are your views on that? I don't know also the amendment that has been carried out in the recent budgets, whether that is simplifying the law or complicating the law.
Thank you, Mukesh, and like I said, thank you for inviting me and Dr. Basim. It's always been a pleasure. You've been a supporter of me and our firm for a very long time. I think I'm just going to take away from what Asim is saying. I've always been soft-spoken, so it's always been my issue. So I think I'll take away from what.
But coming back to courts, in 2018, as I mentioned earlier, during the Trump regime, heavy duties were put on aluminium and steel, and retaliatory duties were put on India by India on 28 items. Further, India was also removed as a beneficiary of the general system of preferences. Now, with the change of regime in the United States, some of those things have changed, some of the benefits have been restored, but not everything is back to what it was earlier. So even today, although when we hear and read about the talks, we hear that India has promised to restore some of the exemptions. The US has said that in the course of discussion that GSP benefits will be restored. But despite Biden almost coming to the end of his term, it has not really happened, and there is still these changes which are
reasoning in terms of taking a view, I won't say differentiating it, but yes, it's steered away in somehow demystifying or giving some clarity in terms of how NOS has to be read or understood. So I think Badri's point is absolutely right. I mean, the God and devil lies in details. The contracts are thrown open for review before the courts much later in time, let's say 5, 4 or 3 years beyond, and at that point in time to be able to recapitulate what was the background, what got into it, and how do you give a fair justification to the court. I think that's a great challenge which always has when matters are being adjudicated by the superior court.
Mr. Asim Chawla. Miss Rina Asthana Kher.
सर इधर देखिए सर.
Mr. L. Badri Narayan. And a group photo, please.